afternoon, everyone. My name is Michelle Moss. My law firm is Johnson Moss, and we love IP. I help entrepreneurs protect their brands so they can focus on profit. So first I'm going to talk a little bit, just a tiny little bit about Trademark, but then and a little bit about myself, and then we're going to get into, I'm going to make all of you here today the smartest people in the room, because we're going to talk about a Supreme Court decision that just came down last Monday in the Lee versus Tam case about the slant. So we're going to talk about that, and that's going to get us all excited about IP, like me, because I love IP.
Get excited!
For myself, I went to a little bit about myself. I went to the United States Air Force Academy, undergrad, and served 5 years in the United States Air Force. I worked in acquisitions. Thank you. Go Falcons. I worked in acquisitions. I actually spent a lot of time here in Orlando working with Lockheed, because they built for us cruise missiles and weapon systems, and that was what I focused on in my acquisitions career. So kill people or break things is what I tell people I do. But it's true. I didn't do it personally, but we had things that did that. So after that, I served my 5 years, went to law school at Notre Dame. Go Irish.
Go Irish. Go game.
So everybody loves that. And then I decided to get into intellectual property law. So why trademark? What is a trademark? Why is trademark so great? Well, I dream at night of little trademarks in my head, like the trademark symbol, which is like a circle with a little capital R in it. It's like, why do you dream of those things, Michelle? Well, I'm weird, but also because I love IP. And we shop by trademarks. Trademarks are what you see, okay? They serve two purposes. One is they designate the source of a good or service, okay? That's the first thing a trademark has to do. The second thing, it has to differentiate the good or service from any other good or service in the marketplace. If a trademark doesn't do those two things, then it is no good as a trademark. So people always say to me, Michelle, I'm a small business, and why do I need to get a federal trademark registration? I don't make a lot of money. Nobody's trying to steal my customers. But that's not really what it's all about. It's all about your brand, okay? Your brand is your trademark. When I travel a lot, and when I travel, I always like to stay in a Marriott. Why do I stay in a Marriott? Because when I see Marriott symbol on the road, to me, I'm traveling by myself. What does that mean? To me, it means a clean room, it means safety, and it means a good price. And it means Marriott rewards points, right? And I know if it's a full-service Marriott, there's a restaurant in there. I don't have to worry about going somewhere else. I know if it's a Residence Inn, there's going to be a kitchen in there. I can make my own healthy meals. So that's your brand, okay? So when people see your business name, when people see your logo, that's what they're thinking about. They're not thinking about, oh, that's, okay, Miller's Oviedo Ale House. Not just those letters. They're thinking of, the last time I ate there, how was that meal? Okay, and the next time they see that name, that's what they're going to think of, right? When I was a little girl, one of the reasons I got into trademark, when I was a little girl, my parents were always throwing parties. My dad was in the Air Force as well. And he had a bar in our house, and there was a bottle of Pinch whiskey. Does anyone know what Pinch is? No? I should have brought the bottle with me today. It's full, it's at my house. But anyway, Pinch is it's by Hague Company. It's one of the oldest trademarks. I believe they got it in the 1800s. But essentially, it's a very unique bottle. It's kind of pinched. It actually looks like a triangle, and it's pinched on all sides. And when I see that bottle, I immediately think of being a little girl, parties at, my dad's house, my dad, my mom, my brothers. I'm immediately taken back to that. So even though I had never tasted Pinch my whole life, when I was out shopping and I saw that Pinch bottle, what did I do? I bought it, right? Because it meant something more to me, okay? And that's a good brand. That's a good mark. Now, the Pinch people are probably saying, we don't care about your family and whatever parties you threw, but that's a brand, okay? It's something that's going to evoke all of the experiences that your customers and your clients come to expect from you and from your business and from your product are all wrapped up in that name, in that logo, in that slogan. So that's worth protecting, right? Think of it the other way. I get a lot of calls from people who unfortunately do not have a trademark, and they're in the same industry as another business who did, and their names are similar. And what happens? All of a sudden, they're in Florida doing business, having a great time, and then here comes another company and sends them a letter and says, guess what? You can no longer do business under that name because we have a federal trademark registration for this name, which is too similar to yours. Now guess what? Start over. So when people say to me, Michelle, I can't afford a trademark registration, or it's not the right time, I say to them, what is your business worth to you? How much time and energy have you put into marketing your name, your brand, your slogan, your logo in your business? What is that worth to you? How would your customers find you if tomorrow you had to start doing business under a completely different name? Would you lose some of them? Would they bother looking for you? Or if there's another company using that name, are they just going to go with that company? How many times have you gotten something in the mail from a company who's changed their name, right? They said, oh, we used to be this company and now we're this. Do you go back and look for that? Do you take that and say, oh, let me remember that. Let me put that up here on my fridge so I remember? No, right? We're stuck to whatever the old name was that we've become used to doing business with. That's how powerful a trademark is. That is your brand. That's how your customers find you. That's how they identify you. That's how they connect with you. So it's very important. And you've already invested so much time and money and energy in marketing and building that brand, not just in, your business cards and your website and your print advertising, but in, the intangibles that you've put in. All the hands you've shaken, all the problems you've solved, right? All the reputation building that you've done. That's all part of your mark, and that's worth protecting. Now, I'm going to make you the smartest people in the room. Lee v. Tam. Anybody heard of that case? It's a fantastic case. Cat's heard about it. Okay.
Yes, Michelle. Tell us all about it.
Oh, it's awesome. It's awesome. Okay, so there's a group of Asian Americans. They have a band, and they called it the Slants. Okay? And they've been using that name since about 2000 or 2005. And then the leader of that band, Simon Tam, he filed a trademark registration by himself, which I don't recommend. You should get an attorney. But he filed a trademark registration for that name in 2010, I'm sorry, after they had been using it for some time, seeking to register that as a trademark for the name of their band for musical services. Now, you're probably saying to yourself, why does an Asian American band want to register the Slants? Isn't that derogatory? Isn't that demeaning? Isn't that degrading? And I tell you the truth, he's not making fun of himself. I have a quote from him because I want to make sure I get it right as to what he said, as to why he named his band the Slants. We want to take on these stereotypes that people have about us, like the slanted eyes, and own them. We're very proud of being Asian. We're not going to hide that fact. The reaction from the Asian community has been positive. So, is this thing on? Did y'all hear what I just said? I would drop this if I could. But seriously, just think of, that would be like myself opening up a law firm and I'm going to call it, coon law or the N-word. Seriously. Think of any racial slur that has been used to demean or to denigrate you, to humiliate their appearance, to humiliate their people, to disparage their culture, and they said, we're going to take that. It's like, you want to call us the Slants? We're going to take the Slants. We're going to own it. We're going to call it our band, and we're Asian American, and we're Tam. There is, or there was, or there still is, a provision in the Trademark Act that says no trademark can be registered if it comprises matter which may disparage or falsely suggest a connection with persons living or dead, institutions, belief, or national symbols, or bring them into contempt. In other words, you cannot register a disparaging mark, amongst other things. There are other rules as well as far as it relates to geographic symbols, flags of other countries, but his trademark registration was denied because they said this is a disparaging term, okay, as it is used towards Asians, and you cannot trademark this, okay? So when you file for a trademark, if your trademark application is denied, you can appeal to the Trademark Trial and Appeal Board, still within the U.S. Patent and Trademark Office. So he did that appeal, and they affirmed the initial refusal. So then he appealed once again and went up to the Federal Circuit Court. Okay, so now we're in a federal court of the Federal Circuit, which hears appeals of this nature. So in that court, normally when you go to a circuit court, and just a tiny little nerd thing here that I have to get by you. So, because there's two different opinions from the Federal Circuit. What happens is when you go to a court of appeals, normally the court of appeals will have 7 judges, but not all 7 judges will hear every case, okay, when there's an oral argument. usually you get a panel of 3 that will hear a case. So in the Federal Circuit, when they first heard the case, it was a panel of 3, and they found that the statute that was the disparaging trademark statute was constitutional, and they affirmed once again the refusal of Mr. Tam's registration. And then sua sponte, that means by the court's own order, not by the order of the parties, they ordered a rehearing of that case in front of the entire Federal Circuit Court, okay, what we call an en banc rehearing. Okay, so sua sponte, the court did that because they felt this was a very important issue. And on that sua sponte rehearing, the Federal Circuit found that, yes, that statute is facially unconstitutional because it is a content-based restriction on private speech, okay? Because you're saying, if I wanted to call myself the greatest Asian band ever, there would be no problem, right? But because I want to call myself the Slants, and someone thinks that that's disparaging, no matter what my intent is or how I want to use that mark, you know, well, that's subjective, okay? That's taking away my freedom of speech or expression, and it's the government that's doing it. Now, can we practice, can we chill speech? Absolutely, I do it all the time. I tell my nephew, shut up, don't say that. I don't like the content of your speech, so don't say it anymore. We can do that, but the freedom of speech that's guaranteed under the Constitution is freedom from government restriction, right, upon freedom of private speech or expression. All right, so in this case, what his argument was, and he appealed from the Federal Circuit, there was an appeal from the Federal Circuit up to the Supreme Court that this statute is unconstitutional as it's facially applied, and that it is private speech. So the Supreme Court came down that there had oral arguments in this case January 19th of this year. So and I was planning on speaking on this case, and the Supreme Court opinion just came out last Monday. So the Supreme Court affirmed the Federal Circuit and said, yes, this is a content-based restriction of speech. This disparagement statute is unconstitutional. All right, so now that has to go back down to the Trademark Office so Mr. Tam can get his mark. But, I mean, this is great. I mean, this is trademark law, right? This is someone who just filed an application because they wanted to be the sole exclusive user of this mark in the entire United States, and they want to express themselves in that fashion, and it didn't work out, and it made it all the way up to the United States Supreme Court. That would be like my dream. I mean, this is a fantastic case for me. You have racism, you have, I'm going to own this term, I'm going to take it away, I'm going to make it strong. I mean, you have all that going on here. You have all this great law and legal arguments. Of course, the government's argument was, this is not private speech. This is, at the minimum, it's commercial speech or it's government speech, which is not that well protected. Okay, but of course, the Supreme Court said no. The Trademark Office does not come up with the marks that it registers, right? It's the people who are filing them. This is obviously private speech, and this disparagement clause is obviously a content-based restriction of that private speech, so it is unconstitutional. So why you're going to hear about this case a lot is not because of Mr. Tam and the Slants, although I love their cause. I don't like their music. Heard it, but I like their cause, and I more power to the people. I know where they're coming from. But the reason you're going to hear this is because this disparagement clause is what was used to cancel the trademark for the Washington Redskins. Did everyone hear about that when that happened? The Redskins football team, their trademark was canceled on the basis of this disparagement clause. So now that it's been declared unconstitutional, they're probably going to try to get that back. So that's why you're going to hear a lot about this case and that decision. So that's why I love trademark. Pinch whiskey, racism, overcoming, Supreme Court. It's good times. I curled up, like I have over there all my little cases. The Supreme Court opinion, what I think was 39 pages. The Federal Circuit opinion, the en banc rehearing, I want to say was 50. And I printed them off this weekend, and I got my favorite adult beverage. And I told my husband I'm going to need about 2 hours because I'm going to read some cases. And he's like, what are you doing? You got a drink so you can read some cases? Because this is fun for me. It's what I like to do. I'm like, I'm about to read a Supreme Court opinion. Yes, it's good times. Give me my wine and close the door. I like this stuff. So does anyone have any questions for me on trademarks or branding, or didn't understand what I said about Levy Tam and why it's so awesome? I don't know if Facebook Live recorded that, but maybe go to my
Hopefully
Facebook.
not. Hopefully not.
Anyone?
I have a
Yes.
shout out because you keep me out of trouble all the time. I'll say, will this work? And she says,
Where'd you get
probably.
that?
Yeah, first thing she asks is, where'd you get it? And I'm like,
Internet. She said no. Absent.
Yeah, be careful. And I'll be talking about copyrights on July 17th at the University Area Business Alliance. But with copyright, be careful because in that case, back in 1984, they changed the law. There no longer has to be a copyright symbol on something in order for it to have the copyright protection. So just because you don't see a copyright symbol on something doesn't mean it's not protected by copyright. Copyright actually attaches or inures as soon as the work is fixed. So as soon as something's recorded or photographed or written down in some form or fashion, there is copyright protection on it by the author.
So who owns photographs when a photographer takes pictures and people find them on the internet and think, that's a nice picture, look really good in my ad? What's your opinion on that, Michelle?
Well, Valerie, thank you for asking. My opinion is that photograph is the property of the author, okay? With copyright, it is an original work of authorship, okay? So whoever takes the picture, whoever writes the photograph, even if you go to a photographer and you have them take a photograph of your family, you don't own the copyright in those images. The photographer does because they're the ones that are author of them. They created them, okay? They created that work. And what a great country we live in that we have laws that will protect everyone's creations, right? That's why people come here. That's why we have such great content. We have such great movies and great music because people know they can come here and they can create those things and they can profit from them because we have laws that are going to protect them and be sure that no one's going to be able to steal that from them and they can profit from that. So just remember that. Even when I was getting my wedding photos done, we asked to get, you'll find sometimes there's a different price maybe. You'll say, okay, give me these prints, but I also want to have them on a DVD, okay, so that I can reprint them anytime I want to. That's because of copyright. You may pay a higher price because now they're saying, okay, I'm going to transfer the actual copyright in this image to you so that you can reproduce it at will. Therefore, there's going to be a higher price just than let me give you these set prints that I prepared of your images that I'm the author of, but I'm going to sell to you and let you have it. So, great question, Valerie. Yes.
I was just going to say that Michelle actually helped me with my trademark for my business, and I can't say enough about her. I mean, she spent so much time, and I learned so much about trademarks from her, but I mean, the amount of research that she had to do to look at Golden Pineapple Interiors and make sure that, like, my brand was right, and she looked all over the entire country. I mean, she found, like, marijuana that was named Golden Pineapple Interior, and, like, she's sending me these things. I'm like, do I need to worry about this? Anyhow, but she was amazing, and so now I do have my trademark, and I'm really happy because I know no one can take it.
Amen. Yes. Golden pineapple. That's only her. And it is some pot also, but that's not. Yeah, I was in Colorado. We found that there's something that's called like Golden Pineapple Awards, and then there's also a strain that's called Golden Pineapple for some reason. That I happened to find in my research. Just an interesting little fact. That's why trademarks are fun. Find all that stuff out. Never. Yeah. Claim the fifth. Good one. Any other questions?
wasn't there a place you could go and look
Yes.
on the internet to see if somebody...
U.S. Patent and Trademark Office, it's uspto.gov. They have a database and it has all of the trademarks that were ever issued and the applications that are pending. Whether they're live or active or dead or inactive, they remain on that database. Now, it's not like a Google search. Okay, you can't just say, oh, let me put in, Hell's Kitchen and see if it comes up. You're not going to get your mark. You have to do a Boolean search on that database in order to get all of the marks to come up. And there's explanation on there how to do that. But if you have questions on that, let me know. But you have to do a particular search to do that. And in actuality, there was the Las Vegas Knights. That Las Vegas is going to have a professional hockey team, right? And they went and tried to get a trademark for their name. Well, guess what? 2 other people had beaten them to it. There was some guy in Las Vegas who had already who had a trademark application pending for Las Vegas Black Knights. And then there was a school that had, as part of their name for their mascot, it was Black Knights of St. Rose or something like that, some school in upstate New York. But again, doing a search is something that I always do before I file for your mark. It's something that you should do because you're not going to get your application fee back if it turns out there's another mark in there that you conflict with and that is senior to yours. They're just going to say, thanks for trying, bye-bye. So you want to do a proper trademark clearance search before you file a trademark application. It's very important. Any other questions? Anyone want to read the 39 page? No.
What's your Facebook page?
Oh, it's Johnson Moss LLC. Yes, go like it, and if you
And
like
go like it. It's on live right
That's
now.
what we're doing.
getting
now.
little, tidbits from me about trademark, and
Like-
trust me, no question is too small. Like I said, I enjoy this stuff. I just curl up with little 39 and 56 page opinions.
There you go.
I read them. I read them to my son. He's 2. And if you want a child to go to sleep, my recommendation is Rule 45 of the Federal Rules of Civil Procedure. That puts him down every time. Or any Supreme Court opinion. That is the rule on subpoenas, just in case you're wondering. Or if you have insomnia, try those.
That's what I need to do.
Any other questions? Thank you very much.
All right.